Planning today is shaped by major legislative reform, climate and environmental obligations, and increasing legal scrutiny.
I think the 2024 is definitely much more readable, and that's really good because that makes things clearer. The public is aware of the legislation.
To bring us up to date with these issues, I'm joined by Deirdre Nagle, partner at Mason Hayes Curran, and a leading practitioner in planning and environmental law. Deirdre, thanks a million for joining me on the podcast.
Thanks a million for inviting me, Sean. Delighted to.
To start off, could you talk a little bit about your career and how you ended up maybe in planning and environmental law, and then also about the work that Mason Hayes Curran do?
Yeah, sure. Well, it was completely accident. It was absolutely no big design. I had fine dreams of being a corporate lawyer originally. And I qualified. I came out of my traineeship with 3 credit cards and ready to party at the height of the Celtic Tiger. And then everything fell flat literally the following day. So I ended up going in-house actually into a state company, and it just kind of gradually evolved. And, people like doing things, that they like, that kind of way. So it just kind of just moved in that direction. And I was in a house for like about 9 years, I think. And then I started Mason Hayes in 2017. And we have 2 partners in Mason Hayes Curran. Shout out to Jay Satin and the rest of the team. And we do like all planning environment matters. Like, to be honest, it's a wealth of riches at the minute, Sean, I'm sure for yourselves as well. Because like everything is trying to be moved at the same time. Whether you're talking infrastructure, housing, renewable energy, gas, like everything is kind of under pressure to kind of move on. And I'm very, very passionate about trying to help move these projects on, and I really enjoy it.
And how much of your work is maybe pure planning? Do you distinguish between that, I suppose, environmental, consenting, all the other licenses piece, and then maybe pure planning? Or are they all kind of mixed up in the projects that you're advising on?
Yeah, my partner Jay would do more on the pure like environmental side, if I can put it that way. And my work partner now, as opposed to my life partner, he contractually makes me make that clear. And but yeah, no, we kind of do the full gambit. Like I do more like in the planning space. So like say, kind of like cradle to grave kind of approach, like take it through the start of the project, strategic planning, like hopefully at the other side of the consenting process, and then withstanding any kind of judicial review and that kind of thing. But there's a huge amount like of requirements particularly from international clients actually, on the kind of more to do with licensing or the circular economy and things like that, or, regulatory kind of more questions. So yeah, there's definitely a good amount kind of across the spectrum.
And all that work puts you, I suppose, very close to how the system is working in practice. And from your perspective, from when you came out, maybe at the tail end of the Celtic Tiger, but even in the last 5 years, what feels most different about the planning system today compared to 5, 10, even 20 years ago? Have you seen a lot of changes?
Yeah, like there's been a huge amount of change. The biggest thing I think that's absolutely drastically changed is we used to have an oral hearing for nearly every single project. And like I was in oral hearings and they're like weeks and weeks and weeks away from your family, down in a hotel in the middle of the country kind of thing, which is fine. I'm very comfortable in that environment. But it was really kind of like combative, I think, I don't think necessarily maybe would have listed maybe the information the board kind of hoped it did. And I do think it's very unusual, like now, like apart from compulsory acquisitions for the board to hold an oral hearing. So I think that's really the most significant change. And obviously there's a huge amount of litigation. I think planning litigation kind of was really coming into its own around that time when I qualified. And it's just become increasingly more. And I think my clients are mostly quite sophisticated, to be honest, and they prepare for that and actually expect it, if you know what I mean. And if there isn't kind of litigation, that's great. But they kind of anticipate that there will be some. So, I don't know how many planning lawyers there were, probably a lot less when I qualified than there are now. It's definitely, I think all big firms have big planning practices now.
And we'll get into the details in a second, but from those international clients that you're advising, I guess the perception that's out there is that Ireland is particularly difficult, particularly slow, particularly combative or legal or whatever. Do you think that's a fair characterization of it? I mean, you're saying that they're building that into their planning for it, but do any of them kind of turn around and say, well, actually, look, we're very happy with how this happened, and actually you're not maybe the basket case that sometimes some people might paint us as, or maybe...
Yeah, no, I mean, there's definitely that perception. Okay, so you're dealing with that straight away. And my kind of attitude is, you know the system, you just have to get through it as quickly as possible. There's no point railing against it. You know, that kind of way, just get on with it. That's kind of my approach. Like, it can be unwieldy at times, but it's really important, obviously, that there is public consultation. We live in a democracy and people need to have their say. I think what's frustrating is once that happens, that people could continue to oppose projects. You know what I mean? There mightn't be the acceptance that, well, this has gone through the consenting process and now it must proceed. And you see that often, especially in respect of like state infrastructure. If bigger it is, more controversy. I think since the Apple judicial review, that's kind of been the perception. I think did a lot of damage internationally for Ireland's kind of brand, but you can get stuff done. You absolutely can. You just have to kind of prepare for these things to happen and go through the process. My kind of frustration, on one hand, I really, really appreciate that the government is really trying to improve things and make the process more streamlined. But on the other hand, if you keep changing stuff, you keep setting up kind of grounds of challenge, people are uncertain. For example, I was advising yesterday on a project and I was just to say, well, the likelihood is part 4, like chapter 4 development's going to come in and it'll be unique and density process. They're like, oh, that's great. Well, what does that look like? And I was like, I have no idea. The regulations haven't come out yet, you know, that kind of way. So this keeps creating uncertainty that people have to factor in, and it costs money because they have to talk to me and they have to prepare for these contingencies. And what if it isn't in? And will I have to split up all my application, like to make, you know, like different applications, or can I include it all in the one? So it makes it very interesting professionally, but it can be frustrating trying to manage it.
Turning to some of the things that are changing, one thing that generated a lot of discussion was the critical infrastructure bill. And some impressions of that online would be maybe a bit like you talked about, that it's possibly going to generate more uncertainty, or it's trying to do things that maybe might not be possible for European reasons or something else. But can you explain a little about what your understanding is about what it was trying to achieve and what's in the bill so far?
What they're trying to do, I think, is like replicate like the project of common interest kind of regulation process at a national level, I think. So basically, the projects of common interest were identified at European level as these are the really important projects that must be progressed at each member state level kind of thing. And the European Commission is going to monitor it. And we're going to set timelines for when the what they call a comprehensive decision has to be taken. So it's basically a one-stop shop to facilitate all consents for any given project. And I think that's what they're trying to do here. I personally think it's a good thing. I think it's good. It lets the state kind of identify absolutely clearly for society and for decision makers, these are our big projects. And they're going to go through the process and we're going to actually all push behind them and people will coordinate. The difficulty, I suppose, is you can introduce legislation and tell people they have to coordinate, they have to fast track. But do they have the resources? Do they have the time? Everything they're trying to kind of move forward. So similar to kind of like Red 3 and this kind of mandatory scoping, it's just, yeah, you might think that's a good idea to front load work, but how do the public authorities have more personnel that they're already so pressed that they have to do all these other requirements? So the other, I suppose, a commentary that you see about is they seem to disapply Section 15 of the Climate Act. And I just query why they're doing that, to be honest. I didn't think it was necessary. And we can go on to talk about Kildare separately, but I don't really fully understand. Maybe they just want to remove it as potential grounds that people would use to challenge these projects. But I don't really strictly see it as necessary, but it's interesting that they have done it.
And you mentioned cool glass, which is something that everybody who's listening will have heard about. Based on cool glass, can you talk a little about the practical implications of that judgment in your view? And what advice would you give planners, either advising clients, but also, I guess, on the other side and assessing applications? What advice would you give them about how they consider our climate applications now?
Yeah, I mean, I think the kind of headline item is they don't have to do it unless someone actually kind of says, we want you to consider section 15 or whatever. So I don't think it's like an obligatory requirement. So if it's canvassed, which it will be in all renewable energy applications, it has to be considered. And basically what the Supreme Court held was that the requirement is more demanding than an obligation to have regard to. And like obviously have regard to is be very familiar with, because like in terms of planning policy, but it is more demanding obligation on the decision maker, but it is less stringent than an obligation to achieve compliance. So if you actually look at the recent decisions from the board, they have a section now. They've obviously kind of produced, and it's how they're going to consider it and go through it. But so I think you need to have, like, again, I suppose it's another paragraph that needs to be inserted in increasingly lengthy decisions that public bodies are having to make. I think it's really useful. I mean, I think it's been very helpful, I think, RED 3 for actually overturning. We've actually a number of refusals or judicial reviews, like, of refusals, and they've been overturned. So because of this point and remitted back. So I think it's really useful, but it doesn't hamstring decision makers that they can't consent to other projects that would be not carbon neutral. For example, we need like OCGTs, or we need data centers, and we need loads of other things like for a growing economy. So I think it's been very useful though for advancing renewable energy projects, I think.
Can you talk a bit about RED 3 as well, which is something else that generated a lot of commentary, probably less commentary, but maybe more discussion about actually how RED 3 is being implemented and rolled out, and your understanding maybe about the current status of the RED 3 regs and how it's starting to work in practice. And obviously it's not fully bedded in it yet either, but I don't know if anybody's entirely clear when it is actually going to become fully operational.
Well, I mean, I think the mandatory scoping, again, as I said earlier, is just like, it's going to cause huge problems. It must be like over a decade before I've seen anyone look for scoping anything, let alone like for wind farms. And like, I kind of think wind farms are pretty well understood. And I don't know how we're going to really elicit a huge amount by this exercise in terms of like identifying new areas for particular applications. Obviously, there could be some circumstances where something will be identified at an earlier point, and that is good. But I'm inclined to think, again, it's just putting a further burden on public bodies that are already trying to do so much. So my concern is that it is going to really kind of grind things down. And I'm sure you've heard, same as I have, Sean, that the mandatory scoping is going to be pushed back to October, which will be helpful. But anyone like has been working towards this deadline and they're getting their applications in now. They are print. They're not going to take the chance. Or they've kind of said, look, we definitely won't make it. So they're kind of further down the road. So they could equally be affected by October. But like, it sounds theoretically good, but again, it's just going to create another step that we just really maybe won't be very helpful to like the decision makers or the public writ large kind of thing.
This is probably more of a philosophical point, but how do we end up in a situation where stuff that is intended to speed things up is possibly going to have the opposite effect? And if that goes for the uncertainty caused by a whole host of legislative changes. But is there a way to, and this probably does bring us now to the 2024 Act in a way, is there a way to do reform of planning in a way that maybe doesn't cause uncertainty, and suggestions that maybe the overhaul that the 2024 Act was possibly too wide-ranging and maybe didn't need to go down the way it did? I don't know if you agree with that or otherwise, but is there a situation where we're actually tying ourselves up in knots through the amount of changes that we're pushing through? And is there a way out of that? Or maybe I'm being very unfair.
No, I don't know. To be honest, I don't think you're being unfair, Sean. I think it's just, look, I suppose in fairness, the last government, they did want to try and make things more streamlined. That was the intention. The Attorney General did a very extensive review trying to work out what it could do. That was kind of, I suppose, generated a lot of controversy at the time because, when people are used to rights, and the reality is in Ireland, people are used to actively participating in environment matters. And if they perceive those are being threatened, people are going to really push back. And that's understandable. So I kind of think to some extent the genie is just out of the bottle. You know what I mean? And it's going to be very hard to go back in because people are used to having engagement with these processes. And that's really important in democratic society as well. So I'm all in favour of that, but I think it's very hard then to institute changes that roll that back, or there's perception of rollback. For example, like third-party appeals, would not be just first-party appeals in Ireland. You would never think that could be possibly removed. Do you know what I mean? So, if you don't change things, you never do anything. So on one hand, you're kind of you're not trying to improve things or make things better. On the other hand, then you have, if you introduce changes, they take a while to bed down and they just create kind of pinch points. The only thing I would think is, it occurs to me that there is a real understanding on behalf of the judiciary in Ireland and a European level that they need to start more kind of balancing getting stuff done. You know what I mean? To stop the rise of authoritarianism, essentially. People saying, we need a big strong man to get everything done because you can't get anything possibly through democracy. And I do think that definitely has landed now. I do think there's definitely much more of a kind of, to my mind, a bit of a pendulum swing towards trying to get development through. For example, is this an error that should stop an entire project? Is it the harmless error kind of doctrine? I think that's really welcome.
And can you bring us up to speed with where we are with the Planning and Development Act from what's been commenced so far? Is there anything that you're looking forward to seeing get commenced? And is there practical stuff that you're starting to see maybe coming out of the 900 odd pages? And obviously there's waiting for the regulations and everything else as well. But yeah, if you could bring people up to speed with maybe what's due to come in and where you think the big game changers potentially are going to be.
Well, it definitely does, it's much more readable. If it wasn't for the Law Reform Commission, God bless them, how could you possibly navigate the planning legislation before that, that kind of way? The 2000 Act was so heavily amended. So I think the 2024 Act is definitely much more readable, and that's really good because that makes things clearer. The public is aware of the legislation. It shouldn't be a mystery. And also the decision maker is it's much clearer. There isn't some provision that was brought in 2018 that nobody's ever heard of, that we're not complying with, that we didn't even realise was there. So I think that's really, really helpful to be positive about it. In terms of is it going to change things, there's good things about, for example, the changing of the definition of transmission, maybe giving a little bit more flexibility. There's an ability to include everything now in one application to a more banal, whereas before you had the expense, frankly, of splitting up applications depending on what the particular infrastructure, the subject of the application was. So I think that will be really good. But to a large extent, I do think it's cosmetic, that you really are going to be doing the same process. You're just going to be calling it a different thing. The Section 5 removal is going to have big, I think, repercussions because, people are so used to that and being able to get their declaration and rely on it. And if it goes past the judicial review period, then you can be fairly comfortable. Whereas the ability now to open up exempted development, you're just going to have to much more carefully consider it, I think.
And in terms of, I don't know if you've had a chance to look at and it's been press releases so far, the exempted development regs and what's coming down the line there. Is there anything, I don't know how many of your clients are the people who are doing Velux windows or getting into trouble about bin storage, but do you have any impressions about what's proposed to come down the line or what's been publicised at least in terms of exempted development?
Well, I think they're going to do more in terms of trying to work with more for state bodies and stuff with a lot of my clients anyway, to try and be a bit more pragmatic to allow more to be built by way of exemptions. The big issue, though, is the kind of carve out if you require an appropriate assessment or environmental impact assessment, that kind of way to de-exempt your development. And it's a very low bar to get into appropriate assessment territory. So the utility of it, I just don't know how well it would be done. But I do think it would be very beneficial if we kind of were a bit more pragmatic about more smaller infrastructure, and trying to get that move forward. Because, it should be obviously in context, but it should be development that we just expect that will happen and will go ahead and be managed correctly. So I think it's useful, but as I said to you, for kind of underlying environmental reasons, I wonder how significant really it will be in reality.
Going really, really micro and probably not your client base, but maybe in some cases, I suppose there's this perception that this is going to be a charter for civil war on neighbourhoods and neighbour against neighbour about that sort of development stuff. How much of that low-level litigation are you just even kind of seeing, not maybe advising on, but crossing your desk? And do you think there's potential for undermining some of the good stuff that's happening in the planning system when it starts getting into the mire about really the minutiae, which are very important to the people involved, obviously, but I suppose can leave a bad taste in everybody's mouth?
I mean, these things are incredibly fraught and it has an absolute tinderbox potential. Yourself, I had the most... neighbours on neighbour action is the most kind of difficult dispute to manage because it's become so personalised. And if I'm going to throw up a modular home in my garden, you know what I mean? And is my neighbour going to be like, what? Sorry, that kind of thing. So I definitely think it's got huge, huge potential to it. And you see loads of these things. People get very exercised with this. An estate goes in the field behind my estate, because I used to have a beautiful view of that field. So these things are very kind of emotive, I think.
Mm-hmm. How much stuff do you do on the development plan stage? And I guess I'm thinking about one of the ambitions of the legislation would seem to be to move a lot of stuff from the decision-making stage through to the development plan, settling a lot of stuff as early on as possible. You've got case like Protect East Meath as well, and changes to the development plans and stuff like that. What are your impressions about what's happening or proposed to be happening in the forward planning space?
I think that's really good. I think we should, as a society, have a much broader discussion and accept things and say, okay, we need this, this and this. And that's the whole point of the development plan process. So I think it's laudable aim, but the reality is people don't focus on these things until it becomes crystallizes. So I just wonder how much engagement we're going to get with people, because everyone has, apart from myself and yourself, Sean, has lives and are not super interested in planning and don't think about it on a daily basis. So they're just getting on with their lives, their jobs, minding their kids. How much are they engaging in? Where's the large energy, usage park going to be for our county? And engage in that conversation. I'm not saying you should not do it, but it's just, I query how beneficial it will be. And I'm also concerned about any kind of the ability of the board to kind of not to make decisions in material contravention of development plans, because that has been absolutely served us so well for a long time. And I do think the Commission has made an awful lot of brave decisions on very controversial projects. And unfortunately, if it was left to kind of the vagrancies of political will, those same decisions just mightn't be made,
We mentioned Cool Glass and mentioned Protect East Meath there, but are there any other recent judgments or upcoming judgments that you think planners should be paying attention to?
Well, I just want to mention quickly, there was an opinion from the Advocate General on the case. You might have heard of it in relation to the Power and Massey references. Essentially, this was a referral from the Irish courts about if there's no site-specific conservation objectives for a European site, can the board basically, or the Commission, apologies, the Commission, I keep calling them the board, whether they are required before an appropriate assessment can be conducted, or even a screening for appropriate assessment. And in a very kind of helpful and I think pragmatic judgment from the Advocate General, basically said that no, when you set site-specific conservation objectives, if anything, that narrows the ambit of the assessment. So, and also if the CGA takes a different view and feels, no, you must have site-specific conservation objectives in place, that it would be kind of limited in how far it would go, as in all the developers who no fault of their own did a good faith assessment, and the decision maker and the commission carried out a decision on the basis of good faith, that wouldn't be overturned. So again, I think that points to a larger discussion that's happening just in the geopolitical context at the minute. We like as Europeans, we need to get more renewables on the system. We need to become more energy kind of independent. It's a real national and European security issue. So I think they're trying to balance those kind of different obligations, and whereas on a few of the earlier cases in relation to the Birds Directive, they may have pushed the envelope a bit, but maybe this is seen a bit of a kind of rebalancing of the different priorities that the European Union is trying to address.
And that's some of the judgments, but you mentioned some brave decisions coming out of the Commission as well. Is there anything that's come out of the Commission recently that you've been impressed by or maybe surprised by, whether something that they refused or granted? Or how do you think the new arrangements, I guess, in the Commission are working in practice?
I think they're working very well. I did find it disappointing a couple of years ago when they started to refuse a huge amount of renewable projects. Good projects, I thought would definitely have gotten consent, and they were refused. But I think that's been rebalanced a bit. One of my absolute pet peeves, though, is when something is remitted, it seems to go right to the back of the queue. And I just think that is just needs to be looked at. And I appreciate, though, in fairness, that they're doing so much. They're trying to, housing is the absolute top priority, and they have to get all the infrastructure in that's actually going to connect all these houses. And then these big infrastructure projects, and there's offshore wind, and that's a new area for the board, and it's extremely complex. So I think they're trying to do a lot. I think it's vitally important that they have to be obviously brave enough to refuse where it's warranted, where this is just not the right development. It can't be just consented development in any case. But also that, even if there's a huge amount of submissions or a project is quote unquote controversial, it's in the national interest and it is a good project and we do need it and they do consent it. So I think the Commission served us very well in that regard.
And then there's one last question I wanted to ask you, which is for planners, I guess, in private practice, advising clients, working with project promoters, or planners working in decision-making bodies, local authorities, the Commission or elsewhere. What suggestions do you have for planners to, I guess, make their lives easier when it comes to the legal risk that you're seeing or that you're advising on? And thinking of planning students and recent graduates in particular, what do you think they need to be aware of to make sure that they're confident when it comes to legal issues? Because sometimes I think it can seem overwhelming, or it can seem that everything is pointless in a way because there's going to be this litigation after. What would you say to people who are actually at the coalface doing development applications or actually making decisions, making recommendations on them?
I would recommend, my advice to that, I said the Commission starts well. I think everyone needs to be brave and stand up for their own decisions, stand over them. We all need to be accountable, and equally, if we make mistakes, we need to acknowledge them. So my advice would be, go to the Law Reform Commission website. They have a tab that says revise legislation. It's really good. Just have that open in front of you, the Planning and Development Act 2000 as amended, or the Planning and Development Act 2024. They identify what provisions will commence. So, and just go through things step by step. Do your best, but don't get so exercised about who's going to pull the rug out at the end. Because I think as a society, we need to have more grace for everyone involved. People make mistakes, that's okay, but don't become paralyzed by an inability to not make a decision. So my big thing is just make the decision and stand over it. Try not to get too exercised about people like me reading your decisions and saying, oh, they made loads of mistakes,
Brilliant. Deirdre, thanks a million for all that.
No problem. You're very welcome.
If you would like to find out more about what we covered in this episode, you'll find notes, links, and more in the description area of this podcast. Do remember to press follow for our show so you'll get the next episode automatically, and remember to share it with a friend in the sector. Just tell them to search Irish Planning Institute on their podcast app. Our podcast today was produced by dustpod.io and brought to you by the Irish Planning Institute. From me, Sean O'Leary, thank you for listening.